Hello everyone. In today's presentation, we are continuing with anticipatory bail and default bail for juvenile offenders. Anticipatory bails are granted to prevent arrest in anticipation of the charges under Section 438 of the Arrest While CRPC or Section 482 of the BNSS. The purpose of anticipatory bail is to protect the liberty and prevent harassment. However, the cases pertaining to juveniles are dealt under Juvenile Justice Act, which emphasizes on protection and rehabilitation rather than punishment. Anticipatory bail under BNSS, Juvenile Justice Act, Section 12, 14 and 15 and Article 21 of the Constitution collectively ensures that juveniles enjoy constitutional protection of the liberty supported by statutory safeguards. Now we understand the provision of anticipatory bail under Section 482 of BNSS. Under Section 482 of BNSS, both Session Court and High Court have concurrent power to grant anticipatory bails by imposing certain conditions. Anticipatory bail can be applied even before an FIR is formally registered. However, anticipatory bail cannot be granted in sexual crimes against children. The underlying principle of Juvenile Justice Act is presumption of innocence, and it focuses on rehabilitation and not on punishment. Therefore, under Juvenile Justice Act, bail is the rule and detention is an exception. Considering this, juveniles can also apply for anticipatory bails under Section 438 of the CRPC or Section 482 of the BNS 2023. There is no statutory bar against juveniles seeking anticipatory bail. However, while considering the judgments by different courts, we can say there are two divergent views regarding grant of anticipatory bail to the juveniles. The first view states that anticipatory bail cannot be granted to juvenile, whereas as per the second view, juveniles are entitled to anticipatory bails subject to the provision of the Section 438 of the CRPC or 482 of the BNS 2023. Here we have listed certain cases where courts have upheld the rights of juvenile to anticipatory bails even in serious offences while balancing the victim protection. Default bail is a statutory right. If the police fails to file the charge sheet within a prescribed time limit, the accused must be released on bail. It is governed by Section 167(2) of the CRPC or Section 187 of the BNSS. Default bail provisions applies equally to juveniles. Section 12 of the Juvenile Justice Act strengthens this by mandating bail unless there are exceptional circumstances. These provisions collectively ensures that juveniles are not kept in custody beyond statutory limits, safeguarding their fundamental rights. Now we would understand the provisions of Section 187 of BNSS. It provides for the procedure for detention when an investigation cannot be completed within 24 hours. The key aspects are as under. First of all, it requires magistrate oversight. Where the investigation could not be completed within 24 hours, the accused has to be produced before a magistrate to authorize further detention if deemed necessary. Second, the maximum period of police custody remains 15 days, but it can be spread over first 40 or 60 days of detention. Third, if the charge sheet is not filed within 60 days or 90 days, the accused would be released on bail. This is also called as default bail. Fourth one, a magistrate can authorize detention even if they lack the jurisdiction to try the case. Here is the list of cases where courts have upheld juveniles' right to default bail, reinforcing that liberty cannot be curtailed due to procedural delays. This series would be continued further to explain other important aspects of juvenile justice in detail. This would be helpful for all the individuals, including professionals in legal field. Do continue to watch this series and share your feedback by way of comments.